The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. This afternoon, we are here for several cases. The first two cases will be set by oral argument, and the final four will be submitted without oral argument, and I will recite those upon the conclusion of the second case. First case today will be State of Iowa versus Matthew Sewell, and the second case is Ronald Rumsey versus Woodgrain Millwork et al. We'll start with the Sewell case, and let's see here. We'll start with the state doing a sound check, please.
Can you hear me?
Yes, thank you.
Yes, thank you, Counsel.
And by the way, we have Justices Apple and McDermott participating remotely today. Mr. Rehkemper, you may give a sound check and then just ease on into your argument.
Thank you, Your Honor. Testing the mic.
Thank you very much.
Thanks, Counsel.
Good afternoon. May it please the court. We all learned really the first day of legal ethics that an attorney-client consultation that knowingly takes place in the presence of a third party is not protected by the attorney-client privilege. A non-privileged consultation with an attorney is really one of two things. One, it's malpractice on the part of the attorney, or two, it's useless. This case really asks the question, what legitimate purpose is furthered by refusing to allow a person a privileged telephonic consultation with counsel? An individual who is convicted and is serving time in the Federal Bureau of Prisons, some of the most serious offenses that exist in the criminal justice system, has the right to an unmonitored, unrecorded, confidential phone consultation with counsel even after convicted. That same privilege exists for individuals serving time in the Iowa Department of Corrections. Certainly an individual who has formally been charged, where paperwork has been filed, also has a constitutionally protected right to a privileged consultation with counsel. So what the state is arguing and what the district court ultimately concluded, though, is that because a piece of paper hadn't been filed and processed with the court system, Mr. Sewell, who is not yet charged, had lesser right to privacy and to privileged communication with counsel than a convicted murderer. How can that be so? If anything, shouldn't an individual in that situation have greater protections? Especially when you consider the predicament that an individual is in at the time Mr. Sewell sought legal counsel. Mr. Sewell had been arrested. He was under a time-sensitive decision-making process. The result of that decision could be definitive of guilt. It certainly would have an immediate impact on a constitutionally protected liberty interest. If ever there's a point in time where an individual should have the opportunity to a full and fair, frank conversation with counsel to obtain adequate legal advice, then would be the time.
In this case, wasn't your client, I mean, he never did have an attorney show up. Is that correct?
That is correct.
Would you agree with me, had his attorney showed up, they would have had that confidential, out of the earshot range of the officer conversation?
That would be a statutory right that would be authorized, correct?
Okay, and you said simply because a piece of paper wasn't filed. We're not talking about a piece of paper. Aren't we talking about a formal charge?
Which is it's the filing through the court system.
Right, but it's got a heavy connotation to it. It's not just a piece of paper.
It has a heavy connotation, but the individual has already been arrested. And you know, if we back up and look at the formation of the attorney-client privilege and the role that it plays in the ancient origins, the attorney-client privilege existed long before 80420 was written. It existed long before the Bill of Rights existed, long before the Constitution existed, long before the colonies were even founded. And it's within that privilege forms a very foundation, essential foundation to our current system of justice. And to say that...
Counsel, if we were to hold that there's a constitutional right to counsel at this stage, what do you do with people who can't afford a lawyer? Do you have to have court-appointed counsel ready to go, or how would that work?
I don't see how that would be a problem, considering the fact that we require court-appointed counsel to be available if they want to interrogate somebody pre-charge. They can invoke and request. And I don't think that we have to...
The difference is you can postpone the interrogation.
Sure.
But you can't postpone the breath test. That has to occur within a pretty limited time window. So are you going to have kind of a panel of, public defender or appointed counsel available in the middle of the night in all these counties? Is that the solution?
County attorneys are on call. Judges are on call. My office is on call. There's no reason that the public defender's office can't be on call. And I don't think that the court actually has to necessarily get to the Article 1, Section 10 argument, the absolute right to the appointment of counsel. What we are asking is that the court simply find that when an individual contacts an attorney and is given, whether it's a statutory right or constitutional right, to consult with an attorney, that consultation is protected by the attorney-client privilege. And in this situation, what we're arguing is under the Due Process Clause of Article 1, Section 9. Because the court has been very clear, the U.S. Supreme Court has been very clear that the communication between an attorney and a client is sacred. We don't interfere with it. And it's improper for the government to interfere with that consultation, with the exercise of that right under any circumstance. And so what we're arguing is we don't have to necessarily reach the attachment. That's a fun argument to talk about, and the court spent 3 separate cases really debating that. But I don't think we have to get here, as long as you can say that when an individual is given the opportunity to consult with counsel, the state has to respect that. What harm comes in giving a person confidentiality for a consultation with counsel?
How about a long period of time happening, perhaps taking up that room? Maybe there's other cases going on. Administrative reasons, not to mention that clicking time that requires the officer to have an answer within a certain period of time.
Wouldn't it be more efficient to allow the consultation to take place telephonically than to say, hey, I'm on my way to the station, and then wait that additional time for counsel to be able to play games with the consultation? That we can have a reasonable application of the time period. I don't think we have to get rid of the 804 reasonable opportunity framework to get to the protection of the attorney-client privilege during these phone calls. And if we look at 80420 and the statutory protections that exist that were drafted and were created long after attorney-client privilege, long after 622.10, long after these other statutes, it makes sense what we are asking the court to do under 80420.
Why can't the legislature created the statutory right in 80420. Why can't they create a right to a non-privileged conversation, which is what we've said they did in, I think, at least 3 separate cases, right?
The legislature can't legislate away constitutional protections. And to the extent that the attorney-client privilege with somebody who is being accused and investigated of a crime is a constitutionally protected right, Legislature can say all day long that you don't have that right, but the Constitution would mandate a finding that that right does indeed exist.
But that gets back to the argument you just said we don't need to reach, which is whether there's a constitutional right to counsel at that stage. If there isn't, why can't the legislature give you something less than a confidential consultation with counsel? Why can't they just say you can call a lawyer, but it's not confidential? The cop's going to be standing there.
There's two rights at place, I believe. It would be the attachment of the right to counsel under Article 1, Section 10, but there's also the protection under due process under Article 1, Section 9 of that privilege, of that conversation, of the sanctity of the attorney-client privilege while an attorney speaks with a client. That's a separate protection that you don't have to necessarily get to the attachment. And I would also argue, and I think it's clear when you read the statute, that the legislature has already specifically provided and authorized an individual to speak with an attorney in a way that would be privileged. The statute is a granting of a right, as it's written. There are no restrictions in 80420. The statute
If we read it, it's very clear that if, when the attorney's there in person, it's alone and in private, confidential, but over the phone, it says phone call in the presence of the officer, or words to that effect. So I think textually, it's not granting a private phone call. Now, is the problem that it's recorded?
The problem is it's recorded but also monitored. In this case, it's recorded, which is above and beyond, way outside the scope. But the statute only says that the call shall be made in the presence of the one having custody. If the person is intoxicated or under the influence of alcohol, the call shall be made by the person having custody as well. If you take the state's interpretation of made to include the entirety of the consultation after the call is made or initially placed, then theoretically the officer is the one that would have the consultation with the attorney. That doesn't further the purpose of the statute that the court has already been very clear is to allow a person to seek and obtain advice on whether or not to consent or refuse to chemical testing. The word made simply indicates the placement, the creation, the initiation. It doesn't say anything or authorize that the consultation be in the presence of the one having custody.
Can I ask a clarification point following up, I think, on what Justice Waterman was getting at? Are you arguing that, are you simply arguing that it's an all or nothing proposition? In other words, there should not be law enforcement present at either end of the conversation, listening to either end of the conversation? Or are you making a backup argument that if law enforcement can be present, they can only be present to hear the detainee's end of the conversation? They can't monitor the line.
I would argue that when an individual makes a request that the privacy be honored, law enforcement must grant that request and must give the person the opportunity to have a full and fair privileged conversation. If the court wants to split that and say, no, only record, certainly that's the court's, within the court's right, but why not just say what harm comes? And that's one question I have yet to have answered by the state or anybody else. What harm comes?
Here's what occurs to me, and maybe I'm wrong, is you have, remember, 80420 doesn't just apply to OWI suspects. It applies to anybody who's arrested. You have somebody who's arrested, and there's an ongoing investigation. This person now has a right to make phone calls to family members and to attorneys. Maybe you want to make sure that that's what's actually going on and that the person isn't alerting Confederates who might dispose of evidence or might take other actions in the midst of an ongoing investigation.
And I have a solution to that problem, Your Honor. That is the qualification of without unreasonable delay. If there, in 80420, it says that the person shall have that right without unreasonable delay upon arriving at the place of detention. So if it is a narcotics investigation, if it's another type of investigation that is ongoing where we are concerned with the warning of Confederates, then that unreasonable delay, they're allowed to take that time necessary, secure what they need to do before authorizing the phone calls to be made. In this case, it's simply an OWI. There's no Confederates to be warned. Also, that it is also protected from the fact that the call is made, placed, initiated by law enforcement so that they can verify that the individual who is appropriate to be contacted under the statute, right? The statute is limited to the right to family member or an attorney. The officer simply places the call, confirms the identity of the individual on the other end, and then allows the consultation to take place outside the presence of the officer, outside the hearing distance of the officer, in a way that allows that full and frank communication, especially with counsel, to take place.
It sounds to me like you're asking for us to read the statute differently than it's written. And tell me if I'm wrong, but the introductory part of 804.20 says without unnecessary delay after arrival at the place of detention to call, consult, and see a member of the family or a lawyer, or both. Then it breaks it down. If you want to do the calling thing, it's going to be in the presence of a cop or whoever restrains you. If you want to see him in person, we'll give you a private confidential room. Aren't you asking us to do differently than what the statute pretty clearly sets out?
No, because the statute clearly says call, consult, and see.
And then it breaks it down into the calling and the consulting. It separates them by two separate sentences.
It leaves out the consulting, and in fact, it says see and consult confidentially in person. And really what that does is distinguish between the rights that an attorney has and that a family member has. An attorney has that right to be face-to-face in person. I believe my time is up if I can see it from here.
Yes,
so
you're correct. Thank you.
I will cede my time. Thank you.
We'll see you again in about 15 minutes.
You bet.
Mr. Sloven.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon, Louis Sloven on behalf of the state. There's a lot going on in this case. I want to start with the simple logic that I think controls on the question of whether these conversations can be privileged. In order to be privileged, they have to be confidential. They can't be made, the statements can't be made in the presence of a third party. I think that, as you pointed out, the plain language of the statute is pretty clear that the officer must be present while the calls are made. Now, I think that you can debate what made means. We get into that in our brief. I think it's still clear that our reading prevails, but even if you think that it's ambiguous what made means, you have to deal with, as you pointed out, the provision of a right to a confidential conversation for an in-person consultation, but not the call, and also the legislative acquiescence in the years since Hellstern, Walker, Craney, when this court said you don't have a right to a confidential call under 804.20. Therefore, nothing said during that call can be privileged. And in Craney, the statement, "I killed my baby," came in as evidence. Now, I think that the question was asked, what's the harm? What's the state's interest here? I would group pretty much all of the state's interests under a broad no shenanigans rule. Justice Mansfield,
Yeah.
I'm sorry, I can't hear you. Justice Apple.
Oh, yeah, I'm sorry. That was my problem. Can you hear me now? Yes. Yeah, okay, thank you. The state can engage in some control over the process. The state can do the call and can identify who's on the other end of the line and confirm that this is, in this case, I guess it was Matt Lindholm, but it could, whoever the attorney might be, or family member for that matter. It's not like there's no control over the communication.
Well, there's not a lot of ways, Your Honor, to verify that the person is who they say they are, to verify a person who claims to be an attorney is an attorney. Additionally, this may have been a straight OWI case, but you can also have cases where there's an intoxicated driver and a lot of drugs or precursor in the car. You could also have evidence of a violent crime found in the car when it is stopped. So to say you can draw a bright line for some OWI cases and not apply this in other cases where there's a very real possibility of contacting a Confederate to get them to destroy evidence, I don't think you can draw that line. And as you pointed out, Justice Mansfield, there's no separate statute for OWI offenses. 804.20 applies to all arrestees who are brought to the place of detention. It doesn't create a special right for OWI arrestees versus everybody else. And so whatever interpretation you apply here, you have to apply to those other cases.
I take it the state's position would be also that the state could disallow confidential in-person communications as well.
Right, I think that that's right. And I think that in order to find, now I think the point is very well, it sums it up perfectly to say, the legislature wrote this right into existence and could choose to provide something less than a confidential phone call unless there is a constitutional right to a confidential phone call or a confidential in-person consultation. So I think that you can't grant the relief that's being asked for here unless you do find that constitutional right, which gets you into the right to counsel attachment issue that my reading of Green is that it closed the door on that. And here's why. Because in Green, yes, there is a difference that Mr. Green was not arrested. At the same time, there was a prosecutor monitoring the interrogation. The interrogation was a source of very powerful evidence against Mr. Green. The choice that he made was going to have consequences for his liberty interest. And yet, this court found that there was no attachment of the right to counsel under Article 1, Section 10, because this is the prelude to a criminal prosecution. It's an investigation into a criminal offense. He's not yet the accused.
Yes, but here we have more than that. I mean, here we have a custodial situation that's kind of similar to Miranda. And indeed, in Miranda, of course, there's no charge filed necessarily. I mean, there could be, but the Miranda rule stands for the proposition that when you're in a custodial situation and a right to counsel is invoked, you get that right to counsel. The right to counsel attaches in the Miranda situation, at least, prior to the charging decision. The rationale for that is because of the coercive environment. In Green, the environment wasn't coercive, unlike here and unlike in Miranda. So it seems to me the real question here is this situation that the defendant found himself in the kind of situation where the state's power has been concentrated on the individual in such a way that the right to counsel should be provided. And the context, it strikes me, is quite different than Green. But why don't you respond?
Well, I think your question, Justice Appel, is implicating two different kinds of applications of coercive power. There's the power in the Miranda context. That's the coercive power that's being used to extract a testimonial statement, a confession, and that's not implicated here. This is not an interrogation.
Yeah, there's even more power here. The power here is to command informed consent. That's even greater than an interrogation.
I don't think so, because the quote from Escobedo is in Mr. Sewell's brief, but that the trial may become just an appeal from the interrogation. But that's talking about an interrogation where you get a confession to the crime, explaining, here's what I did and how I did it, satisfying every element. This is not that. Yes, the breath test is powerful evidence. The refusal, I think, is valuable evidence, but not independently sufficient, probably. But the importance of the evidence doesn't determine whether an Article 1, Section 10 right applies. Picture Mr. Peter Veal running out of the house covered in his victim's blood, encountering the police. Does he have a right to counsel in determining whether to submit to arrest or to flee? No. But whichever one he chooses is going to create powerful evidence in the eventual murder trial against him. And yeah, he's confronted with the awesome power of the state, the multiple squad cars attempting to apprehend him, but he's not yet the accused in a criminal prosecution. And that's the other kind of coercive power that you're talking about, Justice Appel, the kind that is being argued as applicable here, and I don't think we're at that stage. Yes, he was arrested. Yes, there was suspicion that he committed an OWI, and we were conducting that investigation, but the state had not committed itself to prosecute. If you look back at speedy indictment cases like Dennison, you find a recognition that this is the way you know that it's the investigation is that the state is waiting until it has that critical evidence of, are we going to get a blood alcohol reading that is low enough that shows us that we're making a mistake? Or are we going to get a refusal that indicates that he thinks that he's drunk? Or are we going to get a blood alcohol content that's high enough that then we make the decision that's when the positions solidify, you make the accusation, you put the names on the minutes of testimony, and you hold them over for the initial appearance. That's the moment of attachment under Article 1, Section 10. That's a prosecution. That's when he becomes the accused. And no matter what you think about in the cases involving life or liberty, you still need the accused. Otherwise, textually, the right just doesn't apply.
Okay, but so the as you know from reading Sen and the other cases I know you're familiar with, the Article 1, Section 10 arises in part out of concern about the Fugitive Slave Act. A fugitive slave was not an accused in the criminal sense. It was the focus of the proceeding was obviously on the fugitive slave. It seems to me what we draw from the history is, number one, the initiation of a criminal prosecution is not essential under Article 1, Section 10. I think that's clearly established.
Well, I think that's very close, that there's a recognition that there's another class of cases where this right could attach, but definitely there's no support in the debates in the historical record for, in criminal prosecutions, Article 1, Section 10 is trying to attach earlier. And I will point out that during the debates, one of the delegates who's defending this new language specifically says, what if I'm accused of being a fugitive slave? He specifically says accused when he's describing those proceedings, showing
right. And someone who's down at the police station, in a practical sense, isn't accused, just like the fugitive slave is accused. The fugitive slave is appearing before some goofy commissioner. It's not a court type process, really. The situation that arguably the defendant here found himself in was not unlike that of a fugitive slave facing, kind of the coercive power of the state.
So I disagree with that in terms of the timing and the nature of whether it's an accusation. At that point, it's still an investigation, I believe. But I even want to go further than that and talk about the nature of the liberty interest, because this keeps getting brought up.
Isn't the language in the Iowa Constitution that was put in there in recognition, in opposition to the Fugitive Slave Act, that still requires a case, doesn't it? It talks about cases involving life or liberty, as I remember.
Right.
And so in order to have a case, you normally have to have somebody file a case, which you have in the fugitive slave context, but you don't have when somebody is still at the station being investigated for OWI. Am I correct?
I think that that's correct. I think that it would make sense to apply that dual track reading of case being something analogous to a prosecution, but in a imperiling life or liberty context. Also, the way in which the phrase liberty interest is being used.
But maybe not. I mean, Justice Wiggins in his dissent in Sen talked, when he went through some dictionary definitions and so forth of case. Shouldn't we have a functional analysis, which is the right to counsel arises? I mean, the whole purpose of the right to counsel is when the powers of the state focus on an individual in such a way that it becomes almost overpowering. I mean, I'm talking at 50,000 feet generality, of course, but that's when the right to counsel gets invoked.
I mean, I think that you would have a hard time squaring that with Green. He was definitely a focus of the state's power in its investigation. A prosecutor flew to, I believe, Florida to be a part of that interview.
Surely a lot weaker than
I'm just saying, I don't think that view is supported by our case law in this area and our precedent applying and construing Article 1, Section 10. But I need to get back to the nature of the liberty interest, because the liberty interest, every time the driver's license comes up, it's a liberty interest that's implicated. I don't think it's using liberty in a different way than the debates surrounding Article 1, Section 10 are talking about your physical liberty or autonomy. This idea of a liberty interest as a due process kind of a procedural due process, something that's entitled to some level of procedure. If you construe Article 1, Section 10 to create a right to counsel anytime that kind of liberty interest is implicated, suddenly you've expanded the right to a large number of contexts where you would never expect to find a right to counsel, including employment.
Counsel, let's say that I agree with your definition of made, and that the police officer gets to hear the one side of it. What in 80420 permits a recording of the discussion that potentially permits police to hear both sides of it?
So, Your Honor, my answer to that is, if it's not confidential, then it's not privileged. If it's not privileged, there's no prohibition against recording the conversation just in order to create a record of it, to create a record of what the officer hears. Now, if Deputy Grimace had worn a body camera into the room, or, I mean, there was actually a camera in the room where the jail phone was, and we don't look for separate statutory authorization for that recording. It's something that Deputy Grimace was authorized to observe and hear, and the recording, it's part of the no shenanigans policy, that it protects against later claims of, no, I didn't say that. I mean, this is an officer who's working a night shift.
Any place do this besides Dickinson County, to your knowledge?
My knowledge is that some other counties, I mean, I don't have a factual record to go on in this case. My understanding is that some counties do this, not all of them, but it's a common enough practice that it is covered. I mean, this is something that the OWI bar knows how to adapt to and provide advice anyway. And I really don't think that it's accurate that there is no way to provide information to somebody in this kind of situation. Maybe you ask different yes or no questions, or maybe you don't ask questions at all and you just state the applicable thing. I mean, some of the principles that some of the advice that OWI attorneys are giving, such as if somebody has been killed or if you think somebody's been killed, always refuse. You don't need to ask a question about that at all. And I think that maybe the best advice you could give is—
But Mr. Sloven, when we get back to the statute, I mean, it says the call shall be made in the presence. Where does that language give law enforcement authority to actually listen in to the other side of the phone call?
So I would, I see my time's about to expire, but—
Go ahead, you may answer.
Thank you. So I think you derive that authority from the general authority to record anything that they are authorized to see and observe. Also from State versus Fox, from the interpretation of Chapter 808B that says recording jail phone calls is within the ordinary scope of duties of law enforcement officers. At least this, and I do think that from the answer that was given, in order to prevail, this needs to be an all or nothing challenge, that the idea that the call that Deputy Grimace was present itself was not separated out from the fact of recording here to enable you to find any separate kind of violation or deprivation.
Well, let me follow up on that, though. Suppose we took the view that the statute allows law enforcement to make the call and then be present, but does not authorize taping of the entire conversation. So supposing we took that view, what result would happen in this case on that statutory theory?
Well, luckily in this case, harmless error is very readily apparent. If it weren't, that would be a trickier question, and you might have a need for remand to determine, for fact-finding on the effect of the taping separate from the officer's presence. I don't know that you even would. I think you would need to show— I mean, the record in this case is that because it wasn't privileged and confidential, the call, he wasn't going to give advice, and it can't be confidential or privileged because Deputy Grimace was standing there. He said that in his testimony. If there's a third party present, it's not privileged, it's not confidential. So I don't think— even if there weren't harmless error on the facts of this case, I still think that you would not be able to find a violation. I mean, And you're not even talking about a violation of a statute, really. You would be talking about some other freestanding constitutional principle. I just don't see how that could make a claim for relief, especially on these facts where just the evidence of the offense was overwhelming. Thank you.
Thank you. Mr. Rehkemper?
To answer your question, Justice Mansfield, I know for a fact Ida County, Dallas County, Warren County, Boone County, Dickinson County are just a few to name for the court. This issue didn't come out of nowhere with a last-second preparation for it. It's something that has been a problem, which is why it's now up at this court. And I'd ask that if we take a step back and look at the state's argument for what it is. Their argument is that if the formal charging document has not been filed, an individual does not have a protected right to a confidential consultation with an attorney, whether they're in custody, out of custody, or otherwise. Let's think about the dangers in that position. What if the individual is not taken to the place of detention, the jail? What if it's the Sally Port? This court has already said the Sally Port is not the place of detention. What if it's the county attorney's office? What if it's a motel room? And the person says, I'd like to call my lawyer. Law enforcement can say, sure, here's a phone. We're going to record and listen to every part of this conversation, or we're going to put you in an office outside of the formal detention facility and interrogate you. You want an attorney? Sure, the attorney will be here. We can record and listen to that too. What if 80420 gets eroded and they change that and say, there is no in-person, private, confidential?
Could you respond to the state's position that this is not a custodial, it's not an interrogation?
It's not. It's different.
So you don't have and you're not relying on the Fifth Amendment in this case, are you?
No, not for purposes of this appeal. It's not a formal interrogation, but you are still putting somebody to a decision, the decision of which is used against them. This is different than the collection of physical evidence. A search warrant where the attorney is just standing there doing nothing, that's different. Here, the person is seeking advice crucial to a decision they have to make that has legal consequences.
Counsel, let's say that we find that there is no right to this phone call. Is the state still correct that if there's no right to it, the state can provide sort of whatever scope of conversation that it sees fit?
I don't think so, because I think the minute that you allow a person to call and consult with an attorney, you have to respect the privilege that attaches to that. You could say, I may not have the right to call my lawyer on the side of the road, but if they give me that right, it doesn't give the law enforcement the right to intercept it or to listen to that consult. There's a big difference here based upon the fact that Mr. Sewell was attempting to contact and communicate with an attorney. There was also a case in place. The officer had invoked implied consent. He had brought to bear the statutory requirements, the statutory provisions that compel an individual to suffer consequences that vary depending upon the decision.
Isn't the word case different than an investigation, though? I don't think a case had been started. An investigation had.
If you look at the request and notice form that should be in the record, that the officer goes through and fills out a formal document for the Department of Transportation. A case number is assigned.
Not the same case number that would go through our system, though, correct?
No, not a
Don't you
criminal
think this-
prosecution, but at the same time, Your Honor, the Article 1, Section 10 doesn't say it's in a formal prosecution. It says cases involving. A case can be created once a person is put to an important decision. And quite frankly, back in the 1840s when all of this was being debated, I don't think that the legislature was necessarily concerned with people being told they can't ride their horse to town or be arrested for it. So this is something that has been created and is the constitutional provisions have to adopt and adapt to the changes in our laws and in our society. Just as important, Article 1, Section 9 uses life or liberty. No person shall be deprived of life, liberty, or property. We're not arguing that that only applies to the Fugitive Slave Act. The Article 1, Section 10 doesn't say Fugitive Slave Act. It says life or liberty. There are a greater scope of cases. This is one specifically that fits perfectly within a situation where the right to counsel should be respected. Thank you.
Thank you. The case of State of Iowa versus Sewell is hereby submitted. And the next case, while these attorneys are gathering their items, we will then have a brief break to sterilize the table. And once that is done, then the second case of Rumsey versus Woodgrain may approach and get situated. And I previously stated there was 4 other cases. I had a duplicate piece of paper. There's one additional case that will be submitted without oral argument. That is Daniels versus Holtz. But for now, we will wait and have Rumsey versus Woodgrain.